All right, today we have a quick video on how one interprets the Constitution. I have a video on the Constitution that you need to watch for class. I'll put it down in the notes below. Um, that'll kind of run you through some of the Constitution stuff that some of you have done in my earlier classes. For this class I'm referring to specifically is CAS 475. So you can watch this stuff on the Constitution, but for this video, we're just going to talk about how to interpret the Constitution, or how different people do interpret the Constitution. So there's three ways that you could interpret the Constitution: originalist, textualist, or pragmatism. Talk about this sort of pragmatic approach on the second slide here. All right, so we're just defining what these terms mean real quick. So an originalist interpretation means that you interpret based on the original understandings of the author. All right, so now you have to get into sort of like the context in which this law was being written, and you have to get into the mental state of the individuals who are writing it. So what did they think this law meant at the time that this law was being written? So a good example of this would be the death penalty, and a question of whether or not the death penalty is constitutional. There's plenty of ways in which in the 21st century people are saying, well, the death penalty is unconstitutional because it is cruel and unusual punishment. A person who interprets the law as an originalist would say, well, we might find it cruel and unusual punishment in the year 2021. However, when the laws were originally written that allowed for the death penalty, it is obvious that they did not find the death penalty cruel or unusual, because the people who were writing these laws about cruel and unusual punishment were also implementing the death penalty. All right? So obviously the death penalty was happening in the year 1787, right? And no one was complaining about the death penalty being cruel and unusual. Therefore, under originalism, what the original intent of a phrase like cruel and unusual punishment, right? Under originalism, yeah, the death penalty is constitutional, because when this was originally put into place with regard to cruel and unusual punishment, right, the death penalty was happening, right? So that's what originalist means. How would the law have been interpreted at the time it was written? All right, what was the original intent of the law? A textualist is someone who only cares about what the text actually says. They do not care about the motives or the intents of the people who are writing the law. All right, what does the text actually say? Now, there's a very interesting case, or similar, lots of cases, but an interesting sort of line of cases that deal with this issue of what the text actually says. So we're going to use the word use, or the word using here, to sort of illustrate this. Pretty straightforward term, but when you start digging deeper, you realize how complicated it can get with regard to a textualist approach to the law. So there was this dissent by Antonin Scalia in a Supreme Court case, as they were talking about this issue of a gun being used in a drug transaction. So what does the term use mean? So use could mean that I pulled out a gun, pointed it at someone, and said, you know, I'm going to get violent if you don't do X, Y, and Z for me with regard to a drug transaction. All right. I am using the gun to facilitate the transaction of drugs. Right. That would probably be the standard interpretation for what using a gun during a drug transaction means. However, there were courts and there were attorneys leading up to the Supreme Court case who were interpreting the term using a gun to mean a person was found to have a gun at the time a drug transaction was happening. So if I had a gun in the back of my waistband and I engaged in a drug transaction and then I got caught, if it was found that I had a gun on me, even if I didn't use the gun to actually facilitate the transaction, but the fact that a gun was found on me, the fact that a gun was found on me would up the charges with regard to what I was being found guilty of. All right. So Scalia comes in and says, no, using a gun should mean that the gun actually has to be, sort of pulled out and used to intimidate somebody with regard to a drug transaction. You can't just charge someone because they happen to have a gun on them and they're also participating in drug activities, right? So a textualist is looking at what does each individual word mean? What does a common person understand these individual words to mean with regard to how we should interpret the law? Another example that Scalia gives of this with regard to firearms is if forgive me the details. If an individual, if let's say I'm being questioned by the FBI and it's illegal to lie to the FBI. If the FBI ever comes up to me and they say, Josh, have you ever used a firearm? The common understanding of using a firearm is, have I ever pulled out a gun and shot a gun, right? Whether it's in self-defense, right, or if it's at a shooting range, right? Josh, have you ever used a gun? And let's say that I answer no, right? And let's say that for all intents and purposes, let's say that's a true statement. I've never used a gun. But now let's say the FBI digs up an old file of mine and say, well, Josh, it shows here that 20 years ago, your grandfather died and he had an old collection of antique guns and you sold those antique guns to a gun collector, right? It could be argued, and it has been argued, that I have perjured myself because I have used guns before, right? I used guns to engage in commerce in order to, sell the guns and obtain, some sort of, financial benefit from them. So technically I used guns. What Scalia is getting at with this idea of using guns with regard to a textual approach is what is the common understanding of the word, in this case, of the word use with regard to guns and drug transaction, or the idea of using guns. Have you ever used a firearm before? Most people would interpret that to mean, have I ever fired a gun before? Have I ever pulled the trigger? Using a gun in a drug transaction, most people would probably interpret that textually as using the gun to facilitate the drug transaction, using the gun as some sort of intimidation, right, in order to, make the transaction go more smoothly, right, in your favor. So a textualist is looking at each specific word and what is the understanding of that word with regard to how it's being used and then interpreted in the law, all right? So it gets into the minutia and this very close reading of every word, but it's important, right? And plenty of Supreme Court decisions have turned on this sort of textualist understanding of the law, especially in cases like this, right? What does it mean to use a firearm? When we're talking about criminal proceedings, drug transaction, criminal enterprises, etc. So, an originalist, what was the original understanding of the authors at the time the law was written? Textualist, what do the words actually mean? I don't care about people's motives. I don't care about their intents. What do the words actually say? All right. And then finally, we have a pragmatist understanding. And this gets into this debate of a living constitution, right? It needs to be updated for practical times. So you might look at something like the death penalty, right? So look, even if the original people who were writing these laws about cruel and unusual punishment agreed that the death penalty was okay, a pragmatist might say, well, it's the 21st century now, and times are different. So our understanding of cruel and unusual punishment is a little bit different, and therefore we should sort of update the way in which we interpret the Constitution or these laws with regard to the death penalty. So a pragmatist sees this sort of living constitution or living laws, living jurisprudence to constantly update to kind of fit the practicality of the times. All right. Now, the argument against pragmatists is that, we have a way of changing the Constitution, right? We have this amendment process. So if you really believe that the death penalty is wrong and should be unconstitutional, you could actually go in and amend the Constitution to say, we're going to outlaw the death penalty, or you could go and have the laws changed in your state without having the court step in and interpret things differently for you. All right. So those are the three ways in which the Constitution can be interpreted. There's a lot of pitfalls. They're not a lot. There are pitfalls with all three of these approaches. With an originalist, you can never really understand the sort of motives of the authors. With a textualist, obviously, what does the word use mean, right? There's different definitions for different words, and so it becomes very, very hard when it comes to sort of splitting hairs of what certain words mean. And with a pragmatist approach, the fact that we do have ways of updating laws without having the court stepping in and just sort of creating new amendments out of nowhere, we have the ability to change the law, so there's no real reason to have the courts just interpret things differently. You could say, look, courts, the death penalty is constitutional, but now we think it should be outlawed, so we have a legislative process that we can go through, and we have our elected leaders. They can outlaw the death penalty for us. We don't need the courts to step in and outlaw it for us. All right. So these are the three ways in which laws, the Constitution can be interpreted. Watch the stuff below on the Constitution for the rest of class today. All right. See you later.